Hello, friends, and welcome back to another episode of the Liberty Weekly podcast. I'm your host, as always, Patrick McFarlane, and this is episode number 76 of the podcast. And today we're going to be doing something a little bit different here. I graduated from law school officially last Sunday, and right away, automatically, kind of the way that everything works is that you graduate, and then 2 days later, you start studying for the bar. If you're taking the bar, because not everyone who goes to law school is taking the bar, but I am. So I've been studying since Tuesday, and I was trying to think of like a good way to integrate my bar studying with the podcast. And I think the podcast is still like, I take the bar at the end of July. The podcast is still going to be coming out. I'm planning on it until that point, and after that point too. But we'll see how this goes. I want to integrate my bar studying with the podcast. That doesn't mean I'm going to exclusively be doing bar studying things with the podcast. There will be some things that come out on the side. However, I am seeking to integrate the two, and here's a great opportunity here. So today in this episode, I'm going to be going through property law. And I hate property law, coincidentally enough, seeing as I'm a propertarian or a voluntarist. I believe in the absolutism of property rights. However, property law is a really boring part of the law, to be honest. And I've been studying it since Tuesday. But I thought that since property is so important to us, why don't I just go over property law and some things that I'm learning in bar prep? And so I'm going to be doing that. But before I get into that, I wanted to talk about what prompted me to have this idea of trying to bring my bar studying to the podcast. And the story is a little bit convoluted, but it involves a Facebook argument that I got into. And actually several Facebook altercations I've been getting into with listeners of the show or people who comment on the show. And I don't think, because the show is getting more popular, which is awesome, really cool. But with that comes, the social media promotion and the fact that I am just one person running this whole thing. And I think a lot of people, and I don't want to accuse any of the listeners of doing this, because I really love feedback and I love it when you guys interact with my content on social media. But you'll get people who don't listen to the show, who don't know me or anything, just discovering the show, or people who see the article or see the episode and either don't listen to it, don't know me, and then shit comment on it or something, or troll it or whatever. And I'm still in that small stage where I have somewhat the time and ability. Dave Smith kind of talks about how, he wants to, when he first started out, he wanted to comment on every single thing and interact with every single listener of the show. And I now understand why Tom Woods does not, or why Dave Smith does not comment on every single thing. Because people try and pick fights with you, and I don't appreciate that. I do want to discuss things and I'll have a good conversation, but people think that I owe them an argument or something, and I don't, honestly. If I took enough time to really respond to every single heckler's veto that I get, then I wouldn't be producing content because I wouldn't have time to go down these rabbit holes with people. And so the thing that brought this into my mind, the reason why I want to maybe start teaching, or not teaching really, but talking about substantive doctrines of law on the podcast, especially in the form of property law, is because I want you guys to understand this. As I've stated before, the law is not written in a foreign language. It's written in English, and it's accessible. And if I can give, I don't want to be a gatekeeper, and I'll get into the story in a second. But I want you guys to get the tools that you need to interpret the law in your own sphere, or not to interpret it, but to understand the mechanisms at play. And don't construe anything in this episode as being legal advice. It is not. This is, here, I'm going to show you right here. this is my outline that I just made for the show, and we're going to go through it. But this is the outline I'm using to study for the bar exam myself. So I want you guys to be able to have the tools to kind of understand what's going on. One of the things, and maybe this is just, a thought that I have, an anecdote, but one of the things that I think is, in the past, I think people were a lot better educated than they are now. Not in every case, but anecdotally, I've heard that, the cowboys out on the frontier, they actually weren't backwoods inbred hillbillies that, had no understanding of anything. They weren't idiots. They weren't, they were well read, actually, and they had, and like the statesmen of the past, everyone was they were self-taught. People were well read. I think the average citizen had more knowledge of what was going on in the world and a better working knowledge of that. And so I wanted to help facilitate that. And maybe this episode is a testament towards this. But to my story of especially why I wanted, like, the altercation on Facebook the exchange I got into on Facebook that prompted me to try and make sure that my show is educating people. I think that a lot of people are woefully ignorant of the law and woefully ignorant of the current system that we live under. This altercation I got into was with an agorist on Facebook who doesn't know me, doesn't know my content, hadn't followed anything, watched one episode, and then asked me about a legal loophole argument. And if you get into the legal sphere, one of the biggest things that my colleagues or my professors would joke about are people who are sovereign citizens or people who are posse comitatus. And there's some overlap between our communities, I think. I don't want to call out agorists because I consider myself an agorist. I think a lot of this overlap happens in the agorist community. And I think it's very ironic that these people are in the agorist community. These sovereign citizens or legal loophole people or posse comitatus. And you'll get, you'll get legal professionals and my professors and people that I've talked to who will joke about posse comitatus people that come in with this legal loophole. They'll pull out a case ruling from, I don't know, state court from 1875 that, has this one random secluded judgment. And then they want to say that this excludes me from being molested by officers because I have this court ruling that makes me a citizen of, a citizen of a state and not of the federal government. So therefore, the Bill of Rights doesn't apply to me, or therefore I don't have to pay taxes because I'm a citizen of, Wisconsin instead of a citizen of the federal government. Or posse comitatus especially is a wide-ranging group of very erratic and violent people who will hold judges hostage and who will they'll hold them hostage or confront them with guns and say, there's this posse comitatus act, which is an important act. Traditionally, the posse comitatus act, the act in it had separations or distinctions between the military and the police. That's how I know it traditionally. But a certain part of this act in the South, I think a part of it declared that people could form a posse and become a sovereign citizen under the Posse Comitatus Act. And so you'll get people that come into court and say, oh, in South Carolina or something, they declared the Posse Comitatus Act in the 1800s. Therefore, I'm a sovereign citizen. I'm forming my own posse. The police don't apply to me. And it's just stupid. You'll walk into it and the courts will laugh you out. The court actually, judges really hate posse comitatus because they're very violent and criminal in a violating the NAP sense. But so I had this person on Facebook that asked me an argument that I automatically, thought of as one of these legal loophole arguments. And I just dismissed it offhand because, it argued something about state citizen, property interest in state citizenship, and that's just BS, man. You're not going to walk into any court, and they're not going to recognize, oh, this squirreled away court ruling from the 1800s, and that's going to get me out of it. And this guy confused me dismissing his argument, and I did it politely. You know, I said, he asked me for my thoughts. I said, oh, these are my thoughts. And he said, well, that's not good enough. And look at these cases. And I said, hey, man, I really don't know about this. And I said, just because you're a lawyer, you know, doesn't mean that you know every single case that's cited ever. It looks like bogus to me. But it would take 6 hours for me to properly evaluate it, and I think it's bogus to begin with, so I just don't have that time, man. Sorry. And I said, I just don't know about it. And he called me out and said, okay, what did he say? He said, oh, I'm not surprised, you know, no offense, but I'm not surprised that you don't know about it, as like a slight on me or something. And then I took offense, and I was like, you know, you're asking me to go above and beyond, and I know what you're doing. Like, this is a legal loophole argument. It's garbage and it's bogus. And then he called me a gatekeeper in a red coat, and I'm sorry to be airing this drama, especially Facebook drama of the lowest class, but this is what prompted this thought in my head. Just that I don't like arguments that come from legal positivism. And maybe I should bring up legal positivism. Okay. So let's go to the definition of legal positivism. But so just to frame this, I thought it was very ironic that someone who was an agorist was coming to me with a legal argument based off of legal positivism. And sorry, agorists and supporters of Lysander Spooner. I love Lysander Spooner, but he argues from legal positivism. He has a tendency to do this, that he will make arguments based off of the law only being a construction of people. So legal positivism states that natural law doesn't exist, that the law has nothing to do with morals, that basically, if I'm understanding it correctly, that laws are just commands of human beings. And if you are asserting a legal loophole argument, it's ironic as an agorist because you are making an argument from a legal positivist standpoint, especially one that is garbage, because it's just legal loophole arguments like that are mostly garbage, mostly. So I just thought that was ironic, and I want to bring into it because it made me realize that people are completely out of touch with how the courts work currently. And I'll probably, if this whole like bar prep thing kind of works out and this episode is successful, I'll probably get into jurisdiction stuff and constitutional law when I get to that part in my bar prep. And that will be very interesting and very, very helpful for you guys at home. So you can, you know, figure out, okay, what is jurisdiction? What does that mean? In our system, we have, you know, the state courts and the federal courts. How does that work? You know, what happens when laws conflict? So, and more importantly, what authority can I look to that will be persuasive in a certain jurisdiction? And that's why I kind of throughout this whole argument, especially, I looked at it, and the cases the guy was citing was from state court. It was a state court declaring that there was a property interest in a state citizenship, and that's not binding on federal courts or federal citizenship. You know, the federal government doesn't care, and so it's just that Wolf. And maybe I'm mischaracterizing it in this guy. I didn't want to die on a hill in that, you know, for that Facebook drama, but it just seemed like a complete ignorant argument. You know, someone who does not have even the most basic inkling of how our legal system works. And so that's what I'm hoping to get at. 15 minutes later into the episode, I'm making that point. So I apologize for that. I didn't want to get too hung up on this before I got into the substance of what the episode was going to be. But I want to explore this topic. And I love Lysander Spooner, but he does make some legal positivist arguments. So I didn't want to get into that, just too deep into that. But so today I wanted to talk about real property because I've been studying property. I think it'd be very beneficial for ANCAPs and agorists to know how you can own property. I'm talking about physical, tangible estates like land. And this is how it actually works, ladies and gentlemen. This is where the rubber meets the road. So, real property with Liberty Weekly. This is not legal advice, everyone. This is not non-profit for educational purposes only, just for you to know how to enter, these basic legal Western principles of property ownership. So here's a little roadmap of what we're going to go through. And in this lecture, I'm only going to talk about present estates and concurrent ownership interests. All right. I'm not going to be talking about future interests. I might be getting into that. But future interests are really boring to me. And they're super, super duper complicated. Maybe you get into like logic games and like logic puzzles with future interests that I really don't like. In doing this, I'm hoping that A, it will teach you, and B, it will help me study. And so that the time that I spend on Liberty Weekly will not be a quote-unquote waste or distract me from bar prep strategies, or bar prep in general. So real property ownership interests. We have present interests. So this is the ownership interest that you currently possess, at this moment, as opposed to ownership interests you might have in the future. Because you can own tangible physical property, you can have an ownership interest in property currently, but you can also have a future ownership interest in property. And as part of the present ownership, there are also concurrent ownership interests. So the types of present ownership are the fee variety. There's fee simple absolute. These are the types: fee simple absolute, fee simple defeasible, and the fee tail is a concept we'll be discussing. There's also a term, a life ownership. So you could have ownership in a piece of land for just the period of your life that you exist, and then that ownership could revert to someone else after you die. Also, you could have ownership for a term of periods, which is basically a landlord-tenant relationship. So we're going to go over present, but then after we go over present, we're going to get into concurrent ownership interests, which consist of joint tenancy, tenancy in common, and tenancy by the entirety, which I'm not going to talk about so much because it only applies to married couples, and that's kind of boring. So we're coming now to present possessory estates. Here's my outline that I made. There's only one type of freehold estate, and that freehold estate is fee simple absolute. And this state, fee simple absolute, is what we would think of as just a general ownership. So it is the best estate that you can own, fee simple absolute. Say you own your house. You own it in fee simple absolute. It is the best ownership that you can have. It consists of all possible rights that a person may have in that piece of land. So if you own your house in fee simple absolute, there is what property professors will refer to as a bundle of rights in a certain property, or if you can think of it as like a bundle of sticks together, and there's certain rights you have that you can pull out one at a time. Well, fee simple absolute consists of the entirety of that bundle of rights. You have ownership possession in it. It could last forever. It could be, you could die and it will pass on to your heirs, and it could theoretically last forever. You own this piece of land, you pass it on. As long as it goes to your heirs, then you own it. And correspondingly, there's only one way to terminate that ownership, which would be the death of the owner of the property without heirs. So if you own a house and you die and you have no heirs or no relatives or anything, then that it terminates. Your property ownership terminates. And then in our current system, the property if there is a house and the property owner dies without heirs, that house then is sheeted to the state. So the state claims it. So there you go. I know that a lot of you guys are probably raging about that, you know. But so it makes sense in our current system. I would think that so this is the benefit of learning this through me, is that you get my voluntarious commentary on these legal principles. I would think that in Ancapistan, you would, you know, pledge yourself to a certain dispute agency, right? They would take care of you. They would know how to settle disputes with other dispute agencies in the same way that every train track is the same width and Wi-Fi works on every device everywhere. So they would have those similar principles. But I would think that in Ancapistan, if a property died or a property owner died without heirs, I think that property would then go to the your dispute resolution agency, and the dispute resolution agency could either take it for themselves and sell it and keep the proceeds, or they could auction it off to charity, or something like that. That's what I think would happen. So then there's the common law versus the modernly interpretation. And I wanted to make this distinction right away because traditionally, our Western Anglo-Saxon legal tradition is based off of the common law, which is the law of the land, or the law that bubbles up from the customs, from what people are doing anyways in their normal interactions. The way that they normally handle themselves within custom becomes the law of the land, the common law, through the courts. And the court's job is to encapture or try to encapture the pre-existing custom, the way people do things. So in a way, common law is way more libertarian and closer to the people. It bubbles up from the bottom. There's no dictation. Whereas the modern interpretation, they always compare and contrast the traditional modern law or common law with the modern interpretation and the way that the courts are going now. Modernly, a lot of things are based off of statute. So it is dictatorial. It is legal positivism. If I could go back, we're connecting the dots from the beginning of the episode here. It is based off of legal positivism. Under the common law system, in order to convey an estate through fee simple absolute, you had to designate that I'm conveying this piece of property to someone and their heirs. So once again, under the common law system, to convey a fee simple absolute, to convey a property in fee simple absolute, you had to explicitly state to A and his heirs. While in the modern system, this doesn't preclude the common law, by the way. In the modern system, you can have modern courts that make common law decisions based on precedent that can shape the law. It's just generally more dictatorial. So I hope that isn't confusing. But under the modern system, it is presumed that when you convey a piece of property to someone and you say to A, it's assumed that you mean in fee simple absolute. And that's the only type of freehold estate. Unless I'm mistaken, that's the only like complete ownership one where you completely own it. Next are defeasible estates. Now, a defeasible estate is an estate that terminates upon some condition, happening, or event. Okay? So the first one is called fee simple determinable. Now, a fee simple determinable ownership is created or conveyed through durational language. That durational language could be, okay, this property will be given from A to B so long as Democrats continue to be physically removed from the property. I hope you guys like that touch. So an estate in fee simple determinable is created through durational language, and in that conveyance, it states something like this: from A to B, so long as Democrats continue to be physically removed from the property. So long as B physically removes Democrats from his property, this estate lasts. Now, as soon as B stops physically removing Democrats from his property, then the estate will revert back to the grantor. So whoever conveyed the property, they retain the possibility of reverter if the condition is not met. Or excuse me, they retain the opportunity of reverter if the condition is met. So if well, it depends on what the condition is. Excuse me, but A will get the property back if B stops physically removing Democrats from the property. All right? The next one, other language that can be used. A to B, while the school has an Austrian economics program. So A, the owner of the school, conveys the school to B, who can keep it until the school stops having an Austrian economics program. So whoever, and I'm not going to get into the rule of perpetuities today. So if you know what that means, you probably know why I'm not going to get into it. But if you don't worry about it. But so if A conveys the school to B, B can keep the school while there is still an Austrian economics program. But if B gets rid of the Austrian economics program, then the school will revert back to A through the possibility of reverter to the grantor. A is the grantor, B is the grantee. In my last example, A donates a school to B until the school installs safe spaces. So A gives the school to B, and B can keep the school until he installs a safe space at the school. Then the school will revert back to A. So, like I said, a fee simple determinable terminates automatically on the happening of the listed future event. So I think that's pretty straightforward. We discussed that. And then if the future event happens, the estate reverts to the grantor through the possibility of reverter. Okay, the next type of a defeasible estate is a fee simple subject to a condition subsequent. I'm sorry, these terms suck. And that's just part of being in law school, right? So I'm going to try and limit my impact there. Okay. So fee simple subject to a condition subsequent. It's pretty much the same as a fee simple determinable, except the event only opens up the grantor's ability to revert the estate. It opens up the possibility that the grantor could revert the estate back to himself. So let's do an example here. From A to B, but if B does not read Fool's Errand within 1 week, A has the power to terminate the estate. So I'm going to give you the house on the condition that you read Fool's Errand. And if you don't read Fool's Errand, then I get to take the house back. I have the possibility of taking the house back and terminating your estate. The possibility is the digger here, the possibility. I can exercise it or I can choose not to exercise that if I'm the grantor. Another example, from A to B, but if B advocates socialism in any way, then I may re-enter and retake the estate. And this could last forever. Again, I'm not getting into the rule against perpetuities. So if the language in the conveyance regarding the power to terminate is ambiguous, then the courts will try to find a fee simple subject to a condition subsequent. But they usually fail and find a fee simple absolute instead. Okay, so basically, if let's see. Basically, if I write something that looks like this, from A to B, so that voluntarism may be taught on the premises. This is ambiguous language that does not reserve my right as the grantor to terminate the estate, right? So if this conveyance only manifests a wish that voluntarism is taught on the property. It doesn't reserve my right to terminate if voluntarism is not taught on the property. So the court would look at this and they would say, okay, this is ambiguous and doesn't reserve the right to terminate. So we're going to find a fee simple absolute here. That means that the grantee, whoever is getting the property, basically gets all the bundle of property rights. That could last forever. However, the court may award the grantor, which is me, the person who wants voluntarism to be taught on the property, the court may award me material damages for the breach, like money or something. That's all that they may award me. Because I wanted voluntarism to be taught on the property, well, it's not being fulfilled by the new owner of the property, so therefore I get some damages, but I don't have the power to terminate because I have not reserved that in the writing, which usually has to satisfy the statute of fraud. So if you're conveying property like this, you have to have it in writing that satisfies the statute of frauds. Hope that's not too convoluted. And the reason why the court would award damages to me, the grantor, is because I conveyed the property with a covenant on it, which is, well, we might get into covenants later depending on how this episode goes. The last one is fee simple subject to an executory interest. Basically the same as 1 and 2, except it can be so it can be created with either express or conditional language. The only difference here is that on the passing of the terminating event, the property passes not to the grantor, but to a third party. So, for example, we're going to give Murray Rothbard's old apartment from me to B, so long as the NAP is abided by. If not, then Murray Rothbard's apartment goes to the Mises Institute, right? So let's say I'm Lou Rockwell or someone. I own Murray Rothbard's apartment. I want to give it to Jeff Deist on the condition that Jeff Deist abides by the NAP. And if Jeff Deist does not abide by the NAP, then Murray Rothbard's apartment will go to the Mises Institute. Pretty straightforward. Or it could be from A to B on the condition that Cannibal Corpse is played every morning at 10 a.m. If not, then the property will go to C, a third party. So I think that's pretty straightforward. So we've gone through present possessory estates. These are the ownership types, okay? The last one is the fee tail, which is a doctrine of law. It's a conveyance. It's a type of conveyance. At common law, it is a freehold estate that only descended to the grantee's biological children. And you can kind of see why that would be important in the past. It would go something like this: from A to B and the heirs of his body. It could not, a fee tail meant that the property could not be willed, sold, or assigned away. Modernly, though, courts don't like it, and they will just interpret a conveyance through the fee tail as a conveyance through fee simple absolute that is freely assignable. So, just to know, okay, so in summation, then we're going to break for our halftime. In summation, there's one type of total freehold estate that is fee simple absolute. That's the entire bundle. You completely own it. That's what we think about when we think of ownership. Defeasible estates are estates that conclude upon the passing of a current, or upon the passing of a condition or event. It is created with durational language or conditional language. These are fee simple determinable, fee simple subject to condition subsequent, and fee simple subject to an executory interest. Then there's the fee tail that we discussed. Before we break for the halftime, though, one thought here, just that it's very interesting to study property law because it's very old, and you can feel it when you're going through it. Like, when you think of society and civilization coming together, they shed the bonds of aggression, and they institutionalize it. Sorry. They shed the bonds of just, naked aggression against each other, and they decide, hey, it's better if we mutually cooperate. Well, when you come about civilization, you need property. You need property interests. One of the most important things when bringing about civilization is determining how property passes from one generation to the next, and how property passes between private individuals. So therefore, under the common law system, when you get to property, you can just feel how old it is and feel like the fundamental issues that people have been solving for such a long time, since antiquity. How do we deal with property? How do we deal with land? I mean, if you define civilization coming about as nomadic tribes eventually deciding to settle the land and to plot the land and farm and improve the land, then there's nothing or there's not much that's more ancient than property law. All right, so we're going to break here for a second. Now we're going to get into DonorSee, and I'm still trying to... So DonorSee is a charitable application. In the past few episodes, I've been putting a free ad spot for it because I believe in the work that they're doing and I want to help promote it. So I've been picking individual projects. DonorSee, if you don't know, is an excellent philanthropist application on your cell phone and online where you can connect with caregivers and aid workers, and they will create accounts. Here's one for Jesse Schwartz. They will create accounts and they will post videos and pictures of the projects that they're looking to raise money for. And here's a project from Jesse Schwartz. The great thing that you get into with DonorSee is that you get a personalized connection and see exactly where your money is going. And you can see the smile on someone's face when you help them out. Okay. And that gives, you know, the warm and fuzzy tinglies that you get. It also helps someone out directly, very directly. So this is or in a way it's decentralized. I think this is great. Here's a project by Jesse Schwartz. She's going to Uganda to start a mission. It looks like she's doing some mission work. It does include Bible studies. If you don't like that, just donate to another project. There's tons of them on here. She's going to be doing Bible studies, also teaching English and helping women start small businesses to get them on their feet, to support future families and children. This could be a huge opportunity for women in Uganda. She only has $110 left. There's already $390 raised for this project. I think this is worthy of your support. So I'll include a link in the show notes page, and look at this comment section here. If you do donate, let's move my talking head. If you do donate, please leave a comment or email me at patrick.mcfarland@libertyweekly.net. Or just easy enough, leave a comment here and I'll give you a shout out in the next episode. I've had 0 donations from my listenership so far. No one's gotten in contact and I haven't seen any comments, so I'm going to shame you. Donate to charity, at least $5. Come on, people. Don't get a beer or a coffee one day this month and donate to this project. And I'll give you a shout out, okay? It'll be worth it. All right, now, we've moved on from present possessory estates. We're going to go now to life estate. A life estate is a conveyance to someone for the duration of someone's life, usually the life of the grantee. So someone could own something in fee absolute. They convey a life estate to, let's say, Jeff Deist, since I used him already. We're going to convey a life estate to Jeff Deist that will last for Jeff Deist's life. It could be measured by someone else's life, though. So I could give my property. I own property in fee simple absolute. I could convey it to Jeff Deist for the life of his wife or for the life of my wife or someone. So from A to B for the life of C. So as long as C is alive, the estate is part of B's estate. So if I give, let's say I give my house, I have a house in fee simple, I give it to Jeff Deist for the life of his wife. Well, let's say that Jeff Deist dies before his wife does. Well, that the house that I gave to Jeff Deist for the length of time his wife is alive, if Jeff Deist dies before his wife, then the house still belongs to Jeff Deist's estate until his wife dies. So, wow, this is a terrible example. I wish no wrong on Jeff Deist's wife, but you get the example, okay? Life estates can also be made defeasible. So, like, from my house to Jeff Deist for his life, as long as he continues to be president of the Mises Institute. If he stops being president of the Mises Institute, then the house goes back to me through possibility of reverter. So that's a life estate. That's an ownership interest in the land that Jeff Dice would have so long as his wife is alive, an ownership interest. Now, a non-freehold, a type of non-freehold estate would be a term estate that I talked about earlier. Term estates are limited in duration and essentially are just a landlord-tenant relationship. They're very easy to spot just for a term of time, from A to B for 5 years. Pretty straightforward. Okay, now we're going to quickly, I see I'm already at 40 minutes and I don't want this to go over an hour. So bear with me. Concurrent ownership interest. There's joint tenancy and tenancy in common, or tenancy by the entirety, referring back to our roadmap. Co-tenancy comes about whenever a property is being transferred to more than one person to be held jointly. Okay? Oh, excuse me. Yes, co-tenancy or concurrent ownership interests come about whenever property is being transferred to more than one person to be held jointly. There's three types: tenancy in common, joint tenancy, or tenancy by the entirety. A tenancy in common is a form of concurrent ownership, as I just covered, where each co-tenant owns an undivided interest in the whole of the property. A joint tenancy is also a form of concurrent ownership where each co-tenant owns an undivided interest in the whole of the property. Okay, I must have written this wrong. Let's see here. Why? This is embarrassing. Damn it. Okay. So, I can't remember. We're going to look here. I think there's a difference between co-tenancy and tenancy, or joint tenancy and tenancy in common. And I'm just rights and duties of co-tenants. Okay, well this is not right. There is a difference between them. They can't each own an undivided interest in the whole of the property. Maybe the difference will come about as I go through it. So joint tenancy, each tenant has, so the difference between a tenancy in common and a joint tenancy is that in a joint tenancy, each tenant has a right of survivorship, which means that if the property is jointly owned and one of the co-tenants dies, the property passes to the surviving co-tenants automatically. That doesn't happen in a tenancy in common, okay? And I believe that it's in a joint tenancy where each co-tenant owns a divided interest in the whole of the property. I think we're going to be getting to that later. So under a joint tenancy, there is right of survivorship. At common law, the conveyance to two or more people assumed a joint tenancy unless explicitly stated otherwise, right? But modernly is exactly the opposite. In the modern jurisdictions, let's see, move my talking head again. Under the modern jurisdiction, if property is conveyed to two or more people simultaneously, it's assumed to be a tenancy in common, unless explicitly stated otherwise, okay? So, under a joint tenancy, the right of survivorship trumps a will or inheritance by intestacy. So if you own something jointly in a joint tenancy and one of the people dies and that person has passed on their inheritance, has passed on their interest after they died in the property that you own jointly with them, then your right of survivorship will trump whatever will or inheritance that they have. If there's a tenancy in common without the right of survivorship, the joint interest held in a tenancy in common may be willed away or inherited through intestacy. So how do you create a joint tenancy or a tenancy in common? Well, a joint tenancy under the common law required the 4 unities. That is the unity of time. All of the joint tenants must take title at the same time. There must be unity of title, which means that they must take the same title at the same time. And there's unity of interest, which means that each of the joint tenants will take equal shares of the same type. Also, the fourth unity is unity of possession, that each tenant has the right to possess the whole. So I think, yes, and that is the common law. So in order to create a joint tenancy under the common law, you needed the four unities. Well, under the modern jurisdiction, in order to create a joint tenancy, you only need unity of interest and possession. Okay, now so remember when I screwed up when I was talking about tenancy in common and joint tenancy right in the beginning? Well, here's our answer right here. A tenancy in common is where each person, each joint owner owns the entire parcel of the land, but only a % interest in the whole of the land. Okay? And a tenancy in common only requires unity of possession, so it's a lot less rigorous than forming a joint tenancy. So the difference is, the biggest difference between the two are that, one, a joint tenancy only a joint tenancy has the right of survivorship, and a joint tenancy needs both unity of interest and possession, and not just unity of possession, like the tenancy in common. Okay, so once parties own a piece of property jointly, how do they sever that ownership? If they want to head their different ways, what happens to the property then? Well, severance can only happen through an inter vivos act, which means an inter vivos act of one of the parties, which means that the act must be made during the lifetime of one of the parties. Severing a joint tenancy creates a tenancy in common is another rule. So one party seeks a partition action. One party may seek a partition action. Right here. So, or excuse me, this is how it could be severed. It could be severed if one party takes a partition action. It could also be severed if a joint tenant sells their interest to the other tenant. It could also be severed if a joint tenant mortgages his interest in the property. It could be severed that way, and the jurisdictions are split on that. Some see the mortgage as a lien on the property, which does not sever the joint tenancy, and some jurisdictions see the mortgage as passing the title to the property to the bank, and then it's seen as a severance. At least I believe that is how it is. My notes were a little confusing, but I think that those jurisdictions see the mortgage as passing the title to the property to the bank. Not quite positive on that. So that's how you sever joint tenancy. I'm sorry I got a little confused regarding tenancy in common and joint tenancy. I'm still trying to work the differences out in my head. They're in the outline, but they're not up here yet, and that's why I'm doing this episode in the first place. So we've covered what happens when there's concurrent ownership, the different kinds, tenancy in common, joint tenancy, and also there's a third kind between married couples that I wasn't going to cover. I covered how you sever the joint tenancy, how you sever joint ownership. I'm about to cover the partition of the property. So each co-tenant has the right to seek partition of the property. Voluntary partition is done by exchange of deeds or selling the property and dividing the proceeds. Involuntary partition is the result of a partition action filed by one or more co-tenants in court, and the court will involuntarily partition the property. I don't think there would be an NAP problem here because you would have people pledged voluntarily to their dispute resolution organization. So there's an implicit agreement that you would abide by their judgment. And if they judge, you can contest the partition, but if they judge, you've already pre-agreed to abide by the result. So it wouldn't be an involuntary partition. You'd just be disputing it. Like, the involuntariness wouldn't violate the NAP because you've already agreed. Rights and duties of co-tenants. This is the last little bit that I got here. that covers everything. That'll be the end. So rights and duties. So each co-tenant is entitled to possess the whole property. And this applies to both tenancy in common and joint tenancy. If they're denied access to the whole property, they can bring suit for damages or ejectment to eject the others. Now, when it comes to profits of the property, if the profits are produced by one co-tenant's efforts, then the others have no right to the proceeds unless they have been deprived of possession of the property. That makes sense, just blatantly on its face. Now, however, if the profits are from rent of the property, then all parties are due their ownership share of the rent because they all have equal ownership. Unless there's certain parties that have a different percentage ownership. So if there's rent on the property, they get the percentage of the rent of whatever their ownership percentage is. So under the expenses, if there are expenses in the property, each owner must pay a proportionate share of those expenses, whether they're taxes or mortgage payments or what have you. Now, if there's repairs that need to be done, there's no duty for co-tenants to repair, but if one co-tenant does take it upon themselves to repair the property, they have a right to be reimbursed through rent or through the partition and sale of the estate. Pretty straightforward. Improvements. There's no duty to improve the property or right for compensation for the improvements unless the land is sold and the price can be attributed to the improvements. Then the improving co-tenant gets that compensation. So I think that's pretty straightforward. So I'm glad that I was able to cut this in under an hour. It was still a little longer than I wanted it to be. I think that my listeners are a little bit forgiving of that now, though. I think in previous episodes I've talked about how I've always felt guilty for having long episodes and taking up people's time. But I think there's a lot of really good substance and really useful substance here. So this is generally just how property ownership works. These are the different interests. I covered present estates, present property interests. I've also covered concurrent ownership interests. There's future interests, which I could get into, but there are property rights in future interests. You have ownership rights to future interests. It is important, and maybe I'll get into it in a future episode if this works out. So that'll be interesting. So this my outline that I made and that I've been using for this episode, I will include a download link in the show notes page at libertyweekly.net/76. This is episode 76. I think I said that in the beginning. So I'll include a PDF of this outline so you can look through it yourself. I hope this will be very beneficial for you guys. It won't take a lot of your time to learn these different types of estates, and just having that working knowledge, I think, could bring you more prosperity in the future. I think the usefulness of this information is self-apparent. So you know how to support the Liberty Weekly podcast. That is at patreon.com/Liberty Weekly. And I need to be getting some bonuses up there. The last bonus was 13 days ago. So I'm going to have to get some bonuses up there. But there's bonus content, there's extras, there's early access. There's also access to the Rothbard repository, which is an indexed and searchable cache of Murray Rothbard lectures on audio that has been put together by Daniel of Actual Anarchy. I'm just highlighting that here. There's also access to my meme cache that you can get. It has over 1,000 ANCAP-related memes in it. I think that's useful. So those are some of the benefits that you can get there. Also, don't forget about that Liberty Weekly Amazon affiliate link. You can access it at libertyweekly.net in the horizontal bar, the first horizontal bar on the website, or by going to libertyweekly.net/Amazon to do your regular Amazon shopping. I use that to get source material and books to read. As if my wife My wife thinks I have too many books, but let's prove her wrong, ladies and gentlemen. So I think that's about it. I can't think of any new announcements off the top of my head, but check out the MeWe. I'm still on MeWe. Check out the MeWe community. That's at libertyweekly.net/MeWe. That's MEWE. Join us there. There's a growing community around the Liberty Weekly podcast there that I'd like you to be a part of. It's way better than Facebook. Not perfect, but way better than Facebook. And I hope to see you there. Other than that, like I said, libertyweekly.net/76. And if you like this episode, you like the information contained here, please share it. Don't forget to subscribe, rate, review me on Amazon. But if you feel very strongly about it, send me an email at patrick.mcfarland@libertyweekly.net. And it's been fun. There's also a video version, sorry, as usual. youtube.com/libertyweekly, bitshoot.com/libertyweekly. All right, everyone. I think I covered everything. But there you go. So we'll catch you next time. Tomorrow night, I'm going to be having a conversation with the boys at Don't Waste Your Hate. Really looking forward to it. We're going to explore more about police officers, the police, and how libertarians should feel about it, and how some of us do feel about it. So keep your ears and eyes open for that. Should be coming out on Friday. So peace, everyone. Thanks for joining me.